second presenter is Miguel Belmar. You'll see from the short bio in the among the papers that Miguel's got a general practice. He's been in practice for now about 12 years and been at the bar for 8 years. The part of his practice which takes him to, or brings him to this area of the Sentencing Act is personal injuries work, common law. Through that, Miguel has been involved in a variety of Sentencing Act matters, and hence he brings his expertise and experience to us this morning to explain it to us. I welcome Miguel Belmar.
Thanks for that, Michael. What I've prepared this morning is a PowerPoint presentation, and it's my first go at a PowerPoint. So bear with me, they didn't really exist at law firms when I was there in the late 90s. What you'll find in the pack from me is a copy of the relevant parts of the Sentencing Act, and that's sections 85A through to 85M, and we might have a look at those as we go through the presentation. One thing that for me stands out about this particular part of the way that this is drafted is that it's quite user-friendly. You really just step through the legislation and it takes you through what the preconditions are right through to what happens at the end and enforcement. So it's not one of those pieces of legislation where you're sitting there trying to figure out what the hell does it mean. It's as if it's intended for individuals without legal representation to be able to get themselves through it. So if we're trained in interpreting statutes, we're way ahead. So what I've prepared this morning is really an overview. And in the spirit of the time, you'll see I'm playing a flat 3 at the back, who, when, why, and at the front I've gone with a lone striker of how. So the first step is who can bring these applications. What I've set out there is what Section 85B of the Act tells us, and I've just summarised it there. It provides that the court may make a compensation order in favour of a person who has suffered injury as a direct result of an offence. So the two key concepts there are the concept of injury and direct result of an offence, and I'll develop those a bit further in a moment. And the other preconditions are that the court needs to find a person guilty of an offence or convict them, and the court then has the power to make up a compensation order which can be made up of the following issues, or the following heads of compensation. Firstly, pain and suffering. Secondly, counselling expenses, both past and future. Medical expenses, and any other expenses, and noting that it doesn't permit compensation under this part of the legislation for damage to property. Now, what you'll see is missing from that list from a common law perspective is pecuniary damages. So what you get from this type of compensation is something akin to general damages for pain and suffering, not pecuniary loss. So for pecuniary loss, you're still reliant on the common law. Now, when can you bring these sorts of applications? And I've set out there from Section 85A the definition of injury. And if you have a look at the legislation that you've got before you, it sets out there at Section 85, capital A1, what injury means. And what's interesting from the perspective of a common lawyer is that this definition is very broad, and it includes the sorts of injury that you generally cannot recover compensation for or damages for at common law. So A, it includes actual physical bodily harm. B, mental illness or disorder, which we're all familiar with. C, pregnancy. D is what is different about this type of compensation. You can recover compensation under the Sentencing Act for grief, distress or trauma or other significant adverse effects. So your client doesn't need to have suffered, or the victim doesn't need to have sustained a psychiatric injury of the type that you need for a common law claim. So grief, distress, upset, shock gets you through the gate to claim compensation. And again, I've identified there you need a finding of guilt or conviction by the court. And thirdly, that person can include both natural persons and corporations. So you'll see from one of the cases I'll refer to later is that a lot of these applications are made against individuals in circumstances of physical assaults, sexual assaults, but successful applications have also been brought against companies when they've been found guilty or convicted of an offence against bulk health and safety legislation. And the most prominent example of that is probably the ESO applications following the Longford explosions, in which there were a whole raft of applications that were brought, numbering into the teens, maybe even the 20s. And also there's a reported case called Energy Bricks, which I'll refer to in a moment. The other point I've made in this slide about when you bring these applications is that you must commence the application within 12 months of the determination of the court, and you find that at section 85 capital C of the Act, which provides that an application for a compensation order must be made within 12 months after the offender is found guilty or convicted of the offence, and then it sets out who may make the application. Section 85 capital D tells us that an extension of time is possible, but certainly the sort of principles that go into whether or not you extend time are the normal sorts of principles. You need to explain why the delay and then any prejudice that might attach to the defendant in those circumstances. But it is important to note that if your client or if a potential claimant arrives at your doorstep and they are outside the 12-month period, it is still worthwhile to make an application and see if you can have the court entertain it. Now, there's an issue here as to why you would bring a Section 80 a Sentencing Act application instead of going down the common law path. And I've just identified there some general observations as to why you might bring an 85B application rather than a common law proceeding. Firstly, the limitations issues that might exist in a common law proceeding. And the sorts of cases I'm thinking about there are the sexual assault cases that occurred when, for example, the victim was a minor. So you've got someone in their 40s or 50s wanting to bring proceedings for an act that occurred to them when they were a minor, and they will face significant limitations issues in a common law jurisdiction. However, if they are a person who has made a complaint to police in their 40s or 50s as an adult, the perpetrator's been dealt with by the courts, they've been found guilty or convicted, that victim, if they commence their application within 12 months of the finding of guilt or conviction, can have the court entertain their claim without going through without facing all the limitations hurdles they would in a common law environment. The other reason why you might consider these applications is because they can be quick and inexpensive. And the cases talk about Sentencing Act applications being an incidence of the sentencing process, and they are intended to be quick. It's not intended to be a full-blown common law trial to explore every single little issue and to try and go down every avenue that you would in a common law case. For example, having pleadings, having interrogatories, discovery, all those steps you don't have in Sentencing Act applications. It is really a quick and inexpensive way of having access to comp. The other time you might consider it is when the plaintiff is not up to protracted common law litigation, and what I'm referring to there is where you have a plaintiff, for example, who is so severely impacted by the trauma they've been through that they're just not up to the whole process of a common law proceeding, which can take many years. And lastly, you might also consider these in cases where you want to make a claim against a professional who, because of their actions, and I'm thinking here about medical practitioners, psychologists, those sorts of professionals, who, because they've committed a criminal offence, are likely to have voided their liability insurance. So they're the sorts of times that you might think about it. Now, just some tips on the practical aspects. Now, as I've mentioned, this is, or the courts talk about these applications being an incidence of the criminal proceeding. So to bring an application, you don't need a pleading. What you prepare is a document that looks a bit like an originating motion, but isn't an originating motion because there's already a proceeding on foot. And really you prepare a summons to bring the matter before the court, and in that summons you simply set out that you are seeking an order for compensation under the Act, and you file that with the court, and that will be returnable before the judge who made the sentencing orders. So there isn't a particular court form. You need to really trick up a summons with the order that you're seeking and get that filed. If you go to registry and ask them whether there's a particular form, you'll get 3 different opinions as to whether or not there is a form. You can get advice from the bar about those issues, but that's the way that I've seen it done. Once you issue that summons, it'll be returnable generally at a first directions hearing, at which the judge will want to know what all this is about, and most judges that deal with these applications are judges that sit in criminal lists, and they're not common law judges. They are surprised to see common lawyers in their courts seeking compensation, and they are becoming more aware of these applications. And the other issue that it also raises, because you're appearing in front of generally criminal law judges, is that they're thinking in terms of dollar terms like criminal law judges and not common law judges. And that raises an issue that I'll address in a moment. So at that directions hearing, you generally get orders for the exchange or the service of material, and I've set out there further down the sorts of material that you might want to consider putting together when the matter comes on for hearing, and that is that you might want to have your client examined by an independent psychiatrist to have an opinion on the sorts of injury that they've sustained. Generally at this stage in a proceeding, all that the court will have before it is, if there's been a plea of guilty, they'll have before it a summary of evidence that the Crown relied upon, and they will have a victim impact statement. And that will generally be the extent of the material or the evidence that it has. Under the Act, it can also have regard to things like the depositions or other material that might have been admissible at a trial, but the court is not going to have masses of material on the sorts of issues that need to be addressed in the context of an application for compensation. The other issue that you'll consider at the directions hearing is whether you're going to be submitting an updating affidavit from your client if you are appearing for the victim. And that's certainly a matter to consider, in that if you are going to prepare an updating affidavit on behalf of your client to set out how that they are faring post the sentencing of the perpetrator, you might then be opening them up to being in the witness box and being cross-examined. And again, this is a jurisdiction where on many occasions you are dealing with fragile people, and it may or may not be in their best interest to be swearing affidavits that potentially subject them to cross-examination. Now, at the hearing of these matters, once you get to that stage, well, before I go on to the hearing, there's another issue that that arises under the legislation, and that is that in making orders for compensation, the court under the Act can have regard to the financial circumstances of the perpetrator. And one of the issues that in cases I've been in that arises at the directions hearing is that counsel appearing for the applicants will want to know how much money the perpetrator's got in the bank. What have they got in the kitty? What can we have access to? And the Act, although it provides that the court can have regard to financial circumstances, it doesn't require the perpetrator to swear an affidavit or provide any information or any evidence about their financial circumstances. So if they want to be mute about their financial circumstances, there are some judges who take the view that under the Act they have got no power to require them to swear an affidavit or provide any information about their financial circumstances. There are others who seem to take the view that if the Act invites them to take into account financial circumstances, then they can require a perpetrator to swear up to their financial position. So you'll encounter both approaches, and that's where the issue of subpoenas can be helpful, because through title searches and other investigations you might be able to undertake, you might be able to hunt down any assets that a person can have that you'll later be able to hunt down in when you're seeking to enforce. And when I was talking to Michael the other day about this presentation, that's an issue that we were discussing, and that is Sentencing Act applications are all great in theory, but at the end of the day you have to be able to enforce them. So you can get orders for all sorts of money, but where does the dough come from? So subpoenas is one way of tracking down a person's financial position. The other way of doing it is putting on speed dial the Assets Confiscation Office of Victoria Police. And under the Confiscation Act, there are particular provisions of that Act that require that office to hold amounts to satisfy orders made by the courts for compensation. So the Assets Confiscation Office of Victoria Police is well versed in Section 85B. They can be very helpful, and if you are facing one of these matters, I would strongly encourage you to make contact with that office, and they may already have done some of the homework for you and restrained perpetrators' assets. Some examples of cases that I'm aware of where that has occurred is cases involving defendants who were convicted of human trafficking offences, and Victoria Police, as its confiscation office, got involved and restrained the assets of those individuals. They've also been, I'm also aware of cases where they have restrained bank accounts, houses, all the usual sorts of assets that get restrained. But that's also where you need to be a bit creative in the way that you think about what assets might be out there. There's houses which these days, because of our where we are in the property cycle, are worth many hundreds of thousands of dollars. So those sorts of assets are out there. Now, in relation to the hearing and how that proceeds, all judges will have their own way of doing it. Generally, it is not intended to be a lengthy trial. It really is the sort of matters that are dealt with in half a day or a day, where you tender your material and you make submissions about the amount of compensation that should be awarded, and those representing the defendants make submissions about either why no award should be made or that the amount should be minimal. Now, I've set out there some cases that talk about the principles for assessment, and I'm just mindful of the time, so what I might do is just refer you to the case of Chalmers, which is available in Osley, and it's a recent decision of His Honour Justice Osborne. And what he does in Chalmers is that he sets out the principles that he identifies in these sorts of cases based on the authorities. And he sets out the following matters. The determination of the amount of compensation to be paid to an applicant is entirely within the discretion of the court, provided that the claim falls within the category set out under Section 85B2. And they're the matters that I've addressed you on to do with the preconditions. Secondly, an order for compensation is determined by the application where relevant, by the application where relevant of common law principles. However, the order itself is one of compensation, not damages. So what His Honour is telling us there is that you apply the common law principles as to assessing damages for pain and suffering. Thirdly, where a claim for pain and suffering is maintained, it must be a direct result of the offence. Fourthly, the Act does not permit an award for aggravated or exemplary damages which may be sought in a separate civil claim. Fifthly, expenses, medical or otherwise, actually incurred and reasonably likely to be incurred may be the subject of a compensation order. Unlike a common law claim for damages, the financial circumstances of the offender are relevant. And last, a court is not obliged to reduce the amount of compensation payable on the basis of the offender's financial circumstances. It is a relevant but not controlling consideration. Now, so they're the principles that the court will apply in coming up with an award. And in the case of Liang and Chalmers, that was a matter where a mother and a father, the stepfather, brought an application for compensation arising from the death of their daughter. And the amounts rewarded in that case were to the mother $90,000 and to the stepfather $30,000. And they were amounts awarded for the pain, distress that the parents had sustained. Now, there's another case which I'm aware of, and those amounts are sort of generally the amounts that are awarded in these cases. It's in the high, it's less than 100, it's around the 100 mark. Now, there's been a case decided late last year by the Chief Justice, and it's a case which is not available in Osley. It is, the copy I have is marked restricted, do not send for reporting, and I'm informed by Her Honour's Chambers that it is available at the Supreme Court Library, but will not be available in Osley. And this case is called V1 against Zidias, and this is a case that arises from a series of sexual assaults that were perpetrated against victims where the perpetrator videotaped his victims and they were not aware that they were being sexually assaulted, and the 6 victims in this case all suffered varying forms of post-traumatic stress disorder and that sort of injury. And what's interesting about this case is that Her Honour sets out the principles for how compensation should be awarded. And for victim 1, who based on the evidence, suffered a very severe psychiatric reaction. Her Honour awards $300,000 to that victim. And the sums that she awards are from there down. The minimum amount she awards was $150,000. The other awards were in the range of $200,000. So, in many respects, this case sets a different, puts Section 85B applications, I think, in a different light, and that opens them up to a different level of compensation. I said to you at the outset that many of these applications are brought before criminal judges, and criminal judges are not, in my experience, accustomed to those sorts of sums. They're not accustomed to assessing damages and awarding the sorts of tariffs that the common law judges are more accustomed to, but it would seem that in Zidias, the Chief Justice is setting out what the tariffs might be, and they are significantly higher to what they have been assessed as in the past. Now, I am mindful of time, so I will leave it there.
So, Joanne and Miguel, thank you very much on behalf of all of us.